Welcome to Divorced from Reality with Johnny Bardine.
Hello and welcome to Divorced from Reality with Johnny Bardine. Johnny has a mission to help Tampa Bay individuals and families through the most challenging times of their lives, doing so with compassion, fierce advocacy, and efficiency. And it's something he does every day. I am your host, Kevin Rosenquist, and today's episode is an introduction to custody and parenting plans in Florida. Johnny, great to see you again.
Good to see you again. Thank you so much.
All right. So to begin, can you explain Florida's custody laws and how they might differ from other states?
So we touched on this a little bit in the last episode, and I can't really speak on it with regard to other states because I don't practice law in states other than Florida. But in Florida, each divorce case with minor children has to have the establishment of a parenting plan or time-sharing agreement in the case. And as we discussed in the last episode, Florida law has recently changed their statute to now include a presumption of 50-50 time sharing for each children in the case. And that can be altered based on whether you can establish this or that in the best interest factors in the statute. So at a minimum, a parenting plan will have a regular time sharing for the children, usually a holiday time sharing schedule. And then it sets forth some other considerations that are going to be important as you move along. So, for example, how the children are enrolled in extracurricular activities and who pays for them, where the children are picked up and at what time, where they're dropped off and at what time. And by doing so, you kind of get to what are going to be each parent's rights and responsibilities with regard to the time sharing related to the child. And then that gets stamped off by the judge after he finds that the parenting plan is in the best interest of the children. Sometimes you have more or less detailed parenting plans, but at a minimum, that's what they have to establish.
You use terms like time sharing and responsibility. Are there any other specific terms used in Florida that listeners should understand?
Well, those are the two main ones, and I want to be very clear about what I meant by that. The first one is parental responsibility. And so that has to do with the decision-making authority that each parent has with regard to the child. So the default is that the parents are going to have shared decision-making authority with regard to healthcare and education, and will need to confer with each other before decisions are made on that. And then sometimes, if there's a reason for it, one party can get ultimate decision-making authority, which means that the parties will make the best interest to confer on an issue related to education or healthcare. But then if they ultimately cannot agree, one party will make the decision. And then in very extreme cases, one party has sole parental decision-making authority. And that's usually if there's been some detriment to the child from one of the parents, some pattern of abuse or neglect that leads the court to no longer believe that decision-making should be shared between the parties. But with regard to time sharing, the same kind of thing. I mean, for the most part, parties are going to enjoy equal time sharing of the party. Mm-hmm. If there's a good reason to deviate from that, one party will get the majority and one party will have the minority. And then in very extreme cases where there's been a pattern of abuse or neglect, the party can award, or the court can award one party sole time sharing with the child.
You know, as far as you mentioned that a parenting plan can be very detailed, it can be less detailed. What factors usually decide how detailed it is?
Well, the Florida state statute, 61.13, sets forth what a parenting plan needs to establish at a minimum. And so most of the forms that we use have been Florida Supreme Court sanctioned. And at the beginning of each of those forms are some instructions that set forth how the parties need to fill out the documents and what information needs to be included.
Okay. Can you elaborate on shared parental responsibility and what that means in practice and how it impacts the decision-making for the child?
Right. That's a good question because it's one that comes up a lot. If a party has a son named Bobby has to get orthodontic treatment done, then one party will have to inform the other party of that. And they will have to agree on the doctor, on the payment arrangement, on the cost of the treatment, on whether the treatment is necessary before it can take place, if they enjoy shared parental responsibility. And usually there's a component of that says if one party has to pay for uncovered medical expenses, then the other party will reimburse them in a certain number of days. So the idea is that these parents are also adults. And so after the divorce, they're going to be able to communicate together to take action for the best interests of their children and confer on these major decisions, especially related to healthcare, especially related to education, that are going to impact their children.
Is there a difference between legal custody and physical custody?
No, there isn't. And in fact, Florida doesn't even use the term custody anymore. We've reverted to time sharing. So that is a misnomer. I'm not really sure what clients mean when they mean that, but those two things are indistinguishable. So if someone has a physical right to a child through a time sharing plan, that's also a legal right to a child.
Okay, good clarification. Thanks. So what factors do Florida courts consider when determining the parenting plan or custody arrangement?
Well, we've talked about this a couple of times before, and it bears repeating because it's Florida law is replete with this type of language, but we need to look at the best interest of the children. And that's found in Florida statute 61.13. And it's exhaustive. There are 20 factors that the court will consider when determining the best interests of the children. And usually they're about the engagement of each party with the child, their ability to facilitate and encourage a relationship with the other parent, how active they are in the social and educational well-being of the children, and whether there have been any detrimental issues, substance abuse or mental health or physical abuse issues that would impact the children negatively if they were to spend more time with that parent.
How much weight is given to the child's wishes? Can they influence the decisions at all?
Very little weight, especially with younger children. There are no hard and fast rules about a child's preferences or how old they are to be able to make their own decisions in Florida law. So often the court will determine that they're a minor child, and so their wishes won't be taken into account. One of the best interest factors, however, in the statute is the age, education, and experience of the children to be able to make their own decisions and have their own preference. So that's just one factor among 20.
1/20th is the answer to weight, huh?
That could be a short-circuited answer, 1/20th.
Wow. Yeah. Not a lot. If the child's older, like a teenager and prefers to live with one parent or another because they have a connection, they both like to watch a sport together, they like to do this, does that ever factor in or not really?
What you see in those situations, because that does happen, is sort of an organic change or one that's sort of practically driven. So they won't necessarily say the parenting plan was established when the child was 6 or 7, and they needed that kind of structure in a parenting plan. When the child gets to be 15 or 16 or 17, good luck telling them where they're going to sleep and what they're going to do, especially if they're driving.
Yep.
So what often happens is those organically change, and that even if they don't come back to court to try to modify it, which is a different problem, they'll understand the changing dynamics of an older teenager, and then the teenager will sort of go where he or she wants without much issue.
Without much issue. Okay. Yeah. I was going to ask, like, if the parents agree that the child or the teenager can switch and go spend most of their time at the other parent's house, do they have to go to court to rectify that, or can they just agree to do that if it's amicable?
What I tell my clients about the parenting plan is that it's your default agreement. So if you guys can and should flexibly and informally agree to change it as you guys need to. Mm-hmm. But if you cannot, then you revert back to what's on the written page. And if those problems persist, then you can talk to me about a permanent modification of that. Mm-hmm. But in cases as you've described, I think generally parents can work amongst themselves and their older children to figure out what has to happen or what should happen rather than come back to my office.
Is it difficult to change the parenting plan?
Yes, it is. That process is called a supplemental petition to modify the final judgment. And the burden for that is extraordinarily high. So you need to show that after the entry of a final judgment, that there's been a material, significant, or substantial change such that a modification is necessary. That's the first prong. The second prong is that it's also in the best interest of the children.
Right.
And so that's a really high burden. It's become a little bit easier recently. For example, one of the factors that would satisfy a substantial change would be that the change was unanticipated. And so that ruled out children just getting older and outgrowing their parenting plans, as you've described, because that's an anticipated change. So in the revision to the statute, they removed that unanticipated language and make it a little bit easier. But
okay.
supplemental actions are difficult and long, and the burden is high. So if people can try to work it out before talking to me, they should.
Yeah, that's good tip. So you talked about, situations of domestic violence, substance abuse. How does Florida law address custody in cases where those unfortunate situations exist?
Carefully, and I think increasingly therapeutically. And I'm thinking about a couple cases that I've had recently. So I think if a parent is facing an issue, like a substance abuse issue, the court is not going to foreclose forever their ability to gain substantial or even equal time sharing with the child. But what they will do is put the pause button on it a little bit to set up some safeguards for the parent to get better and I think prove themselves a little bit. So in a lot of my cases where those are issues, there'll be like a court-ordered substance abuse evaluation and then maybe a regimen of drug testing in order to show that parties clean and sober before they regain their full parenting time. The same thing with mental health stuff. If those are issues, then I think we'll set up a system of evaluation by which after that the parent can regain their parenting time. Physical abuse and neglect and abandonment, those are different issues, and those are the court takes a different view on those. So it will be difficult for a parent to reestablish some meaningful time sharing if there's been a pattern of physical abuse.
Are there any specific protections that are in place for children in high-risk situations?
Well, there's always the Department of Children and Families. So in really particularly difficult cases, you could call Child Protective Services will come out and do a home study of the children and perhaps take them into the dependency action. Those are for extreme cases. But the court has emergency ex parte power. So if you filed an emergency motion on these issues, the court could, without a hearing, make a decision and suspend the time sharing of one of the parties to protect the children.
In your experience, what steps are good for parents to take to help their children adjust to the final custody arrangement, especially if the process was contested or difficult?
Right. So I think, and I've talked about this in a lot of these episodes, I think we cannot understate the importance of good therapy and mental health in this case, because I can fix these legal issues, but I can't fix all the mental health stuff. And I can't help all the time with the macro issues. So getting that underway and getting both parties and the children in therapy pretty soon in the process, I think can help a lot with the adjustment that they're going to have to take. And also time helps. Like these cases often start with a very high emotional temperature that kind of levels out over time. And the reason is that people have just gotten used to the circumstance. So children are very adaptable. But we shouldn't mistake that for them not having feelings about these things. So they can be adaptable and resilient, but then they're going to sort of harbor trauma that they won't understand for some time after that. Yep. And so we needed to understand that they're going to get through it, but they're going to need some help to do it.
Yeah, that's a good point to say that they're adaptable, but they do have feelings that need to be acknowledged and understood.
Right.
Yeah. No, that's a really good way to put it. For anyone listening who might be going through a custody dispute in Florida, what advice do you have for them as they sort of work through this whole parenting plan, court process, everything that they're going through?
Not everything is an emergency, right? Just because if you feel anxious about something or urgent about something doesn't make it so. And just because your partner who you're divorcing is feeling anxious or urgent doesn't make it so. Don't let someone else's anxiety become your to-do list. So you've got to slow down a little bit. Do the things that you know are the right things to do. So taking care of your family mentally and emotionally and financially, getting into therapy if you need to, and consulting with a lawyer pretty early on in that process so we can sort of gameplay the practical realities of a divorce. Those are things that they should be doing.
Okay. And I think we talked about this a little bit in the last episode, but it's pretty important to think about legal representation pretty early, in your opinion?
Yeah, because, I went through my own divorce and I thought, I'm a pretty good lawyer. So I represented myself for a period of time in it. It went poorly. And it went poorly because I don't have the perspective that is necessary. So too close emotionally to those issues. And so I think that's what I tell a lot of clients, which is part of the reason you need a lawyer is to be a buffer between you and the thing that's driving you crazy, handle some of that stuff. And so I think it's really important to get a lawyer because the client doesn't have the perspective and they're too emotionally close to that subject matter. The other thing is that the work is a bit tedious, very forms driven and difficult for a layman to figure out and time intensive. And so that if you can get another lawyer to handle, get another person to handle that kind of stuff, the really tedious paperwork that divorces require, then I think you should do that.
Yeah, that's great advice as always. Well, thank you for tuning in to Divorced from Reality with Johnny Bardine. To connect with Johnny, you can head to bardinelawfirm.com. And of course, please like, subscribe, and review our channel here. We love having you be a part of our community. Johnny, thanks so much for being here and all the insights.
Thanks, man. I really appreciate it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.